Thanks, Shawn, for inviting me. As an introduction to my presentation today, I'd like to share with you where I come from as a researcher in political science of all disciplines when I discuss the topic of returns and restitutions of cultural heritage, and how I will try to link this question to the broader field of heritage crime that we are looking at today. So most often, returns and restitutions are studied from a legal perspective. That is, whether there are international norms that allow for this process. For example, the 1970 UNESCO Convention, the 1995 UNIDROIT Convention, directives from the European Union, or bilateral treaties. For example, the US has several such treaties with Latin American countries. So these texts imply the recognition that objects were displaced illegally, possibly because a crime was committed. Now, for a long time, the question was also debated from the point of view of the holding institution, particularly the so-called universal museums, which have only very recently started to pay lip service to the idea of returning part of their collections, if at all. Now, the movement of decolonizing museums has started in smaller institutions and is really gaining some traction. And this movement, among other issues, acknowledges the colonial or imperial nature of many museums' collections and accepts that returns may be a way to redress historical injustices, even if no crime has been characterized. So in that context, my research, I was trying to take a different approach to returns and restitutions to understand who wants the return of cultural heritage objects in the claiming countries and for what reasons, and what are the political stakes of the claim in those countries. So my premise here was to reject any idea that return claims are natural, if I can use quotation marks, and that a country would eventually, inevitably ask for lost objects. And so that really meant understanding heritage as a construction and not as a natural concept. So I will talk today about claims for the return of displaced cultural objects to Latin America. And I thought I would start by telling you a little bit about the circumstances in which some of these objects were taken from their original archaeological context or country of origin. So all the 6 cases I rapidly want to describe have one thing in common, that the claiming countries do not have a legal case to claim them back, even though the circumstances of their removal, as we will see, is at the very least controversial, which in turn raises ethical or moral dimensions of returns and restitutions. Specifically, I will use today the word return to actually distinguish from cases of restitutions in which some legal, either national or international norm can be applied to the case and allows for the restitution of the stolen object. This is not the case here for the reasons I will present. So I will start with a case that some of you may remember from only a few years ago, that of a collection of artifacts that were unearthed in Machu Picchu, Peru, by archaeologist Hiram Bingham between 1912 and 1916, and that he brought back to New Haven with the agreement of the Peruvian government at the time. Now, the caveat here was that these objects were to be returned after 18 months. And the Peruvian government did indeed request the return of the objects twice in the late 1910s and early 1920s. But there was no further claim later on until the early 2000s. And at that time, Yale's argument was that the statute of limitation had expired, so that the university was under no legal obligation to return the collection. Yet, through a decade of contentious negotiations, Yale agreed to return the entire collection in November 2010. Now, in my second case study, the Museum of World Culture in Gothenburg, Sweden, agreed in 2014 to return a collection of funerary textiles from the Paracas culture that had been donated to the museum by a former Swedish consul in Peru. This gentleman had bought the textiles on the Lima market, and the textiles had been looted from an archaeological site south of Lima. And so the consul took those textiles with him back to Sweden. All this happening in the 1930s, at a time when there were already laws on the protection of cultural heritage in Peru, but certainly very limited capacity for enforcement, and also probably a very limited conscience among the broader population of the importance of cultural, of past remains in cultural heritage. So the main difference between this case and the previous one is obviously the attitude of the museum that acknowledged the illegitimate circumstances of the removal and agreed to the return. Now, moving on from Peru to Mexico, I also wanted to tell you about the case of Montezuma's featherhead, or Penacho de Moctezuma, as it's called in Spanish, which is very different because there is much uncertainty around the object. What was it really used for? Was it actually a featherhead at all? Did it belong to the last Aztec emperor, or maybe some of his priests? There are competing theories on these issues, on these questions. What we do know is that the object was sent to Europe as early as the 16th century, though it is unclear in which circumstances. Was it stolen from the emperor's palace? Was it maybe a gift from Montezuma to Charles V? And it is because of all these ambiguities that the museum in Vienna has refused to consider the Mexican requests for its return to Mexico. So during that time, in the past decades, the featherhead has actually become a symbol of official Mexican nationalism through the presentation of a replica in the National Museum of Anthropology in Mexico City. So I put you both here. On the bottom right of the page of the slide, you see a picture of the original featherhead in Vienna, and on the bottom left with the red background, it's a picture of the replica in Mexico City. Now, in my second case from Mexico, the objects were clearly looted in the 1960s from Teotihuacan, which is a famous archaeological site just north of Mexico City. And we're talking here about frescoes from a housing complex. So that happened in the 1960s before the 1972 law in Mexico that has strengthened state control over all antiquities, yet there were already laws in Mexico at the time protecting cultural heritage. However, because it was demonstrated that the frescoes were taken to the US before the 1970 Mexico-US agreement on the illegal export of antiquities, a judge in San Francisco found in the late 1970s that the De Young Museum, which had received the murals through a bequest, was entitled to keep them. Through several years of negotiation, the museum and the Mexican government reached an agreement in the mid-1980s, by which half of the murals were returned to Mexico, but the other half remains in San Francisco to this day. Now, moving on to my third country case study, Colombia. I wanted to talk about a collection of 192 objects in gold that were from a funerary bundle that was unearthed in 1890, that was bought with public funds by the Colombian state to represent Colombia at the Hispanic American exhibition that took place in Madrid in 1892. And the following year, at the close of the exhibition, the collection was gifted to the Queen of Spain by the Colombian president. So we're talking here about 1893. And it is rumored today that the Colombian president was actually the lover of the Queen at the time. Today, this collection of objects in gold is displayed at the Museum of America in Madrid. And a couple of citizen initiatives in Colombia would want to see the collection back to their country. And they are actually backed in their efforts by the judiciary branch of the state. The Constitutional Court this ruled in 2017 that the Colombian executive should indeed claim the return of the collection from Spain, because the Colombian president at the time, in 1893, had acted against the provisions of the 1886 Colombian Constitution. Yet since that ruling, Madrid has not budged so far, arguing that the collection was a gift, and the Colombian executive has actually showed little goodwill in trying to obtain this return. And finally, the last case study I wanted to talk about for today is that a collection of 35 funerary statues from the archaeological site of San Agustin in southern Colombia. Those were taken in the 1910s by German archaeologist Theodor Conrad Preuss. And he brought them with him back to Germany after World War I. And since the 1920s, the statues have been in the collections of the Ethnological Museum of Berlin, which was recently absorbed into the newer and larger Humboldt Forum. Here again, citizen initiatives in the town of San Agustin that are backed by the judiciary, again through a lower court decision this time, are asking for the return of these statues. But the Colombian executive shows little interest in negotiating with Berlin. I hear that negotiations would be taking place, but their result or their advancement is unclear, mostly because neither the museum nor the Colombian government agrees to communicate with the local community about the state of these negotiations, again, if they are happening at all. All this in the context that German museums have agreed to return quite large quantities of objects and human remains to countries such as Nigeria and Namibia recently, as well as to First Nations in Australia and the United States, among other countries. So what is detaining the Humboldt Forum at this point of returning these statues to San Agustin that were taken without any proper authorization at the time remains unclear. So from there, I would like to explore with you some questions that arise from the non-applicability of national and international norms, such as the conventions that I mentioned before, and from the non-recognition of the criminal nature of the removal of the cultural objects. So for me, the main question is, why do countries such as Peru, Mexico, and Colombia want the return of these objects? And I want to offer at least two explanations here. In the book that Shawn made me the favor of mentioning earlier, I try to offer distinctive and competitive and alternative explanations, but I would like to develop these two for today with you. So the first one really has to do with the construction of official nationalist discourses in Latin American countries, particularly those with an indigenous pre-Hispanic past that has been constructed as glorious and as the precursor of the contemporary nation. So it is not every or any object that is claimed in this sense. Otherwise, all objects in Western collections could be claimed, which is very far from the case. So the objects that are claimed are those that can serve a discourse of continuity between the contemporary nation and this deep sublimated past that jumps over the colonial Spanish period. This construction of a national or nationalist discourse is really a path-dependent process that started mostly in the early decades of the 20th century but it is never fully achieved. So the effort to coalesce a nation together is a never-ending project. And archaeology has been put to the task of this process. And I think we've seen other examples with Stephanie of this earlier today. In Latin American states have built, was Paula Lopez Caballero refers to, thinking about Mexico, about the legitimate monopoly over the use of the past. And in this process, the contemporary nation states have appropriated the remains of past indigenous cultures and made them nationals. This process of construction is still going on in the late 20th and early 21st century. Because nation states are in crisis, or consider themselves as in crisis, as they face the contestation of their monopoly over the use of violence on their territory by non-state armed groups, for example, or by criminal groups. They also face the reduction of their prerogatives in economic and social matters through the implementation of neoliberal reforms. And in that sense, the cultural field is open to be reinvested by the state. But they also face internal processes of democratization which have opened up the possibility for alternative discourses to emerge about the nature of this past heritage. And one last thought of this, I tend to think that return claims beyond their legal standing are more useful to the purpose of constructing national discourses as long as they have not been accepted. So indeed, it is possible for a government or for some political actors within a country to mobilize public opinion around this issue for only as long as the claimed object remains missing. And I think that the case of the Machu Picchu collection that did return to Peru is interesting in that regard, because the fate of the collection seems to have completely disappeared from the broader public eye since the objects have returned to Cusco specifically. Now, the second thread of thoughts I would like to develop in the time that I have remaining regards the very nature of public policy making. And I believe that one of the reasons why states claim these objects now, today, in the early 21st century, is because, again, through a past-dependent process, they first had to build their capacity to care for the remains of the past in order to be credible interlocutors to Western museums. So over decades, and I'll be referring specifically to the three countries that I'm dealing with today, have built museums. They have trained experts and qualified staff. They have passed legislation and strengthened their capacity to enforce this legislation. They created administrations specifically dedicated to the management and preservation of cultural heritage. To the point that today, nobody can really deny the capacity of these countries to properly care for the objects. Nobody can deny the quality of their museums and the level of expertise of their staff. Even though all this process often means the exclusion of local, subnational, or indigenous communities from the claiming process, as the example I was giving you from Colombia seems to validate. The claimed objects belong to the state, and the state only has the capacity to care for these objects upon their return. So some rare exceptions to this principle exist in the region. In the case of human remains in countries such as Argentina or Chile or Bolivia. Yet, even in those cases, the negotiations at least often involve the states, even if indigenous communities, for example, seek the return of human remains from museums in Western Europe or in North America. Now, going back to the issue of heritage crime, the three countries I'm discussing today all face vast issues. Archaeological sites being looted before they can be excavated, churches that have to remain closed in order to avoid theft, Yet these countries are also being very proactive, though not always successful in fighting this trafficking. So for example, Mexico and Peru were among the promoters of the 1970 UNESCO Convention. The three countries publish red lists of unexportable objects, or objects that are particularly sought by collectors. These countries collaborate with customs in the global north to seize objects when they are discovered. These past few years, Mexican authorities have been particularly vocal to try and stop auctions of pre-Hispanic objects in Europe. And I think that these efforts to curb the traffic offer some positive reinforcement to also obtain the return of long displaced objects. Again, with all the limitations that apply in how successful these efforts are. But seeking the return of long displaced objects demonstrates that the state is serious in its current efforts to protect what is still underground and to curb traffic. And on the other hand, the likelihood of recuperating an estranged object is stronger if a country can demonstrate that it makes substantial efforts to avoid new objects from leaving its territory. I'll leave you with this idea for today, and I look forward to questions if there are any, and if we have time for conversation. Thank you.